Thank you all. Please be seated. Good morning. This is the time set for oral argument in our case number CACB 210635, Las Ventanas versus Arizona Department of Environmental Quality. Do we have a sign-in sheet for counsel? If you could bring that to me, I would appreciate it. Thank you very much. Each side is allocated 20 minutes for argument. Appellant, you can reserve a portion of your time if you wish to do so, but if you wish to do so, you need to keep track of your own time. The court will not do that for you. Please also let us know if you're having trouble hearing us. Acoustics sometimes they're predictable in our courtroom, they're less predictable here, and we'll do the same if we're unable to hear from you. Now, out of respect for counsel and to avoid embarrassment, I would ask everyone to make sure those cell phones are turned off so our proceedings are not interrupted. We've read the briefs. We've conferenced the case this morning, actually earlier in the week. We encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted in due course. So please, as you begin your argument, state your name and the party that you represent. With that, Mr. Zimmerman, you may proceed.
May it please the court, I'm actually Jeffrey Gross for
yes.
Appellant Las Ventanas 1 LLC.
I appreciate the correction. I apologize for the error.
And I am trying to, I'll rely on the timer. As you know from reading the briefs, the crux of this case is that a decision arising out of a motion to dismiss. We all know the standard for the benefit of the audience. The standard is that a motion to dismiss should not be granted unless the plaintiff is not entitled to relief under any interpretation of facts that are susceptible to proof. And that's where I want to focus my oral argument on. We've raised issues of duty, sovereign immunity, other notice of claim issues, but I think the real decision here and where I want to focus my time, unless the court has any other questions, is on the motion to dismiss and the grounds on which it was granted. And that is essentially the trial court laser focused on one sentence in internal ADEQ meeting minutes that were unverified, that were unilaterally prepared, that we don't know who the author was. Las Ventanas had no input in putting them together and writing them. They did not approve them once they were done. They had no obligation to review them. And moreover, the one sentence at issue is not supported by any corroborating evidence, and it is directly contradicted by Las Ventanas itself. And that one sentence, which the trial court interpreted against Las Ventanas, and this is a case about inferences, drew the inferences against Las Ventanas when, in a motion to dismiss, those inferences should have been drawn in Las Ventanas' favor. So our position is that the trial court erred in dismissing the complaint without leave to amend, based on a misapplication of the law related to the standard of proof in a motion to dismiss context.
Counsel, let me ask you, we don't know the author. You're right, but does that matter?
It matters in this respect, Your Honor. We don't know who the author is, and we don't know if it was the minutes were even prepared by somebody who was in attendance at the hearing. It might have been a secretary. It might have been somebody who was writing the minutes based on a report from somebody who was in attendance at the meeting. So yes, it does matter. And in addition, because the sentence, in our view, and based on the evidence that we have provided, what's in the record, is capable of interpretation, and we're entitled to take the deposition of the person who prepared the meetings and those folks who were in attendance at the meeting.
You attached the minutes
I did.
to your complaint, and you quoted, although a different portion
Correct.
of the minutes in the complaint. What's the court to make of that?
The court is to make of that I did not cite those minutes for the proposition that the trial court relied on and that ADEQ cited them for.
But they were properly part of the record that the court
They are,
could consider.
absolutely, they're part of the record. I agree. They're not an admission. Even judicial admissions are subject to amendment. They're subject to revision. And quite frankly, this might not be relevant, but when I was reading the minutes, I interpreted them the way that I explained in the brief, that Mr. Tate at the meeting was concerned about contamination, the presence of contamination underlying the property. That's why they were communicating with ADEQ in the first place. That's why they were there at the meeting. That's what gave rise to the letter dated July 29th, 2016, where ADEQ said, yeah, we got you. We are the ones with the expertise. We're going to take care of this for you. We will, not might, not we could, we will continue to remediate the Perryville property, the property next door, to ensure that your property, Las Ventanas property, is not impacted. So in terms of your question, this all came up after we attached the minutes. After we had a chance to review public records, we made a public records request to review the records. We supplemented the record. Even judicial admissions are entitled to amend the pleadings in order to explain the party's position once something becomes an issue.
They are, but your first amended complaint was the subject to the motion to dismiss. You sought to file a second amended complaint, and it included the same set of minutes as an attachment, and I think there was one word changed in the paragraph where you quoted those minutes, but almost identically.
Yes, but there also in the second amended complaint was a clear statement that Las Ventanas did not discover the contamination until August 30, 2019.
And I understand there was a reference to, again, a report that we don't have, that your client indicated it had received on or about that time from an engineer from ADEQ. But if the question is inquiry notice for filing a notice of claim, why would that preclude looking to the March 29 minutes?
Because if you're talking about investigation, really what you're saying is should have known, knew or should have known. And so if the question is not new, if there is a disputed issue of fact or a factual way of interpreting the minutes, either because of what they say or because of other evidence in the record, if that's beside that box is over here, then you're looking at should have known. And should have known is inherently a factual issue. And so you have to look at the context of what we have pleaded to determine whether they should have known. I'm not saying that doesn't, I mean, the ADEQ is entitled to raise as a defense, certainly, but it doesn't form the grounds of a motion to dismiss.
What's your best case for the proposition that inquiry notice, in terms of notice of claim, is always a question of fact, cannot be decided as a matter of law?
I think I don't have a specific case in mind other than the standard, the regular standard for a motion to dismiss, unless there is it's conclusive that a plaintiff cannot state a cause of action under any set of facts or any interpretation of the facts that may state a cause of action that's susceptible to proof. Should have known, though, is inherently factual. What was going on in Las Ventanas' mind? And I can put that in the context of this case and the facts that we've pled to show that there is certainly a question about should have known, because that's what it gets down to is the facts. And the facts are these. From 2012 to 2016, ADEQ had monitoring wells on the Las Ventanas property with Las Ventanas' permission. They were checking those monitoring wells. 2012, they tell Las Ventanas the property is clean. 2016, they tell the Las Ventanas the property is clean. July 2016, they're telling Las Ventanas all the time that the property is clean. July 2016, we have the letter, what I call the remediation letter, that says not only is the property clean, but we have had monitoring wells on the property since 2013, 2015. We have been checking it. We will continue to remediate to ensure the U parcel is not impacted. We have a body with the expertise of remediation telling Las Ventanas in July 2016 that they are going to keep watching the property. They're going to continue to remediate so that to keep Las Ventanas property from being impacted. From 2012
Counsel, can I ask you a question?
Yeah.
You want it to be ambiguous, the line that plays against that you should have known. You want us to take the fact as facts, the line you include in your statement of facts, and then there's also language in that meeting minute that said that the regional groundwater, not just the groundwater under the Perryville site, but the regional groundwater had elevated levels of nitrate, which renders the water unsuitable for human consumption. So if we're on kind of a should have known standard, doesn't the totality of that meeting note make your case much harder?
I might make the case much harder. Doesn't mean the motion to dismiss was properly
I mean
granted.
your argument that the motion to dismiss was
No, and here's why, because this is also in the record. The groundwater was not potable. That's in the record. Excuse me, Exhibit 10 to our statement of facts in response to ADEQ's additional statement of facts. The groundwater was not potable. And in the same minutes, it says that Las Ventanas is not going to use the groundwater
correct. You had a different water source. So, but doesn't just the idea that in the region, the groundwater itself, which runs certainly doesn't stop at the borders of the Perryville site, give you notice?
No, because nitrates are irrelevant.
What are irrelevant?
The nitrates are irrelevant because the groundwater, nitrates are in the groundwater. They come from fertilizer because fertilizer is made up of nitrates. They come from other byproducts of agriculture. The nitrates are in the groundwater, yes, but the groundwater is not going to be used to serve the Las Ventanas property. So that doesn't put Las Ventanas on notice of anything because it doesn't matter.
Counsel, again, asking for a best case. What's the best case that somehow the other party said, oh, don't worry, don't worry, don't worry. We know you're worried, don't worry, gets you past a motion to dismiss at that point? Because that seems to be what your argument is.
Yes.
We had concerns, but they told us it was going to be all right. That doesn't seem to me to get you past into a lack of notice sufficient to extend the statute.
Well, I think it does because, and I'm not saying that it extends the statute. That should have known is when the statute accrues.
And that's what extends it.
Well, it's when it accrues. Maybe it's just semantics. Okay. But that's not the only thing. I mean, what we have in terms of the should have known, that's one element of it, is we have the expertise to tell you we're going to remediate. We have monitoring wells. We're going to go forward with that promise, and it can be done within 24 to 36 months. Or we hope it can be implemented in 24 to 36 months. So in March of 2019, move forward to March of 2019, we're still within that 24 to 36 months. And Las Ventanas gets a letter on April 25, 2019, that says, hey, look, we're still going to remediate the Perryville site. Mentions nothing, going back to the March minutes, mentions nothing about, this is just 1 month after March 2019, mentions nothing about any contamination on the Las Ventanas. Doesn't say we're going to remediate the Perryville site. And the Las Ventanas site because you told us now there's contamination. Just as we're going to remediate, we're going to continue to remediate the Perryville site, and that continues. They continue to make statements. We're going to do the remediation, and they take actions to do that. They hire a consultant. They perform ozone injections. They continue with monitoring wells. They're doing all of these things going forward that indicate to Las Ventanas, and this is in Mr. Tate's declaration, they're doing all these things going forward that tells Las Ventanas, we got this. We're going to take care of it, just as we promised back in 2016.
Well, and counsel, let me ask you, remediation efforts in varying fits and starts have begun when the lusts were found in 1991. So there's been either certainly a lot of time, maybe a lot of activity, I don't know, but there have been stops and starts. But I read from your filings that your client's claim is not due to contamination of the adjacent site, but it's from the physical invasion of Las Ventanas property from the plume that on that other site that
Yes.
ADEQ failed to remediate. So how, I continue to struggle, and again, I'm back to those minutes, right? But how, Mr. Tate expressing concerns due to the presence of contamination on the Las Ventanas property derived from the leaky underground storage tanks, that's a pretty jarring sort of statement, and it's attached to your complaint.
And we say that's wrong. Those minutes are wrong. It's a word choice somebody at ADEQ made, the due to. I mean, the due to, I think, is really the applicable language there. Change that. Change it to about. Mr. Tate's concerned about presence of contamination. That's a totally different thing than saying, I'm concerned that I know that there's groundwater, there's contamination under the groundwater. And you put that together with all these other facts that show that there wasn't contamination, or nobody said there was contamination. Monitoring wells didn't show any. ADEQ never pointed any out. There's nothing in the record that says there was contamination. And Mr. Tate, and in the Second Amendment complaint, we say didn't know about it until August 30, 2019. So I think the law is pretty clear that the allegations in the Second Amendment complaint for purposes of a motion to amend are taking as true in a motion to dismiss, and we have facts susceptible of proof. Mr. Tate's own words that Las Ventanas did not know about it until August 30, 2019.
Although just procedurally, the proposed Second Amended complaint is not what the motion to dismiss was addressed. Those are different sort of motion for leave to amend versus motion to dismiss.
I'm sorry. But I think the law is that if there's a, and I have a case, I believe I cited the case in my brief, I don't know about it, but that if there is a motion, if there's a motion to dismiss and there's a proposed amended complaint, then for purposes of the motion to dismiss, the allegations in the proposed amended complaint should be considered.
So, counsel, I mean, I'm struggling with the idea that this is a nuisance that you're arguing. That nuisance existed in the 1990s. Your client was well aware of that nuisance on the adjacent property. How do you get past that? I mean, this is not a new nuisance that you can say only arose when we found out that it had migrated. Then you're trying to argue a trespass, it seems to me.
No, absolutely. It is absolutely a new nuisance, and it's absolutely, I think a trespass or a nuisance law is better fitting in this because it's contamination. But the nuisance was on the Perryville site in 1991. There's a vast difference between being next to contaminated property and having contaminated property of your own. And ADEQ even implicitly recognized that in 2016 when it said, hey, we know the Perryville site is contaminated, but we're going to continue to remediate to make sure that your parcel isn't impacted. That's very clear that ADEQ even understood the difference, that there's the difference between being adjacent to contaminated property and then having contaminated property of your own. And that was also in Mr. Tate's declaration. And again, to the extent there's a question about that, that's a question of proof, not motion to dismiss. We should be entitled to amend the complaint to reflect that. And again, it's an inference. These are all good arguments, I suppose, that ADEQ could make on a motion to summary judgment stage if the evidence supports it. or at trial, but it's not grounds to grant a motion to dismiss.
You're at
I'd
2 minutes. if
like
you
to
got
reserve
welcome.
the 2
Of
minutes
course,
I have for
of course.
rebuttal.
Yes, thank you. We'll hear next from counsel for ADEQ, Mr. Clore.
Good morning, Your Honors, and may it please the Court, Vale Clore on behalf of the Applee Arizona Department of Environmental Quality. With me at council table is my partner, Holly Zoe, and representatives of ADEQ are in the audience as well, as including General Counsel Edwin Slade. Your Honors, it is beyond dispute that ADEQ is tasked with deciding which leaking underground storage tanks, of which there are dozens, if not hundreds, in this state. Class is apparently starting, Your Honors. There are hundreds of leaking underground storage tanks for which ADEQ, the director of ADEQ, is tasked with prioritizing based on the greatest threat to health and the environment, human health and the environment. That's in 49-10-18. What Las Ventanas has asked the trial court to do, and what Las Ventanas asks Your Honors to do today, is to simply skip over that analysis, to jump to the front of the line based on some purported promise. But Your
Counsel,
Honor,
help me understand that, because I
Sure.
thought we were here on the timeliness of a notice of claim.
we certainly are, Your Honor. This is context for and will help inform why the notice of claim is problematic. Your Honors, the notice of claim, and you heard from Mr. Gross say, my friend Mr. Gross hedged a little bit as to what the law is. And one of Your Honors asked, well, what is the case that says that that the accrual of a claim is always a question of fact? There is no case that says that, Your Honor. Mr. Gross didn't have one because the law is the opposite. Humphrey versus State, Your Honor, is a JMAL case, a judgment as a matter of law case, where the court decides and this court rules upon accrual of a claim as a matter of law. Accrual can occur as a matter of law if there are no facts in dispute. And in this case, Your Honors, we have no facts in dispute because on the four corners of the First Amended complaint and the four corners of the Second Amended complaint, the notice of claim is simply untimely.
Counsel, let me ask you, if I heard you right, you indicated Humphrey is a judgment as a matter of law case,
Yes,
correct? That's a quite different record than we're presented with here, right?
Certainly, Your Honor. It is a different, 2 points. First, you're absolutely correct that it is a different record. But taking the allegations of the First and Second Amended complaints is true. It is manifest that the claims were untimely, and I'll touch on that in a minute. Second, Your Honor, you are absolutely right that the record is different. Despite Las Ventanas' attempts to rely upon things set forth in the motion for summary judgment and the cross motion for summary judgment, including the declaration of Mr. Tate, those are not before this court on the question pending before it, which is whether or not Las Ventanas could state a claim based upon the language in the First Amendment complaint and the Second Amendment complaint. So what Las Ventanas doesn't touch on in its briefing at all is what Your Honors touched upon this morning, which is inquiry notice. When did the sum total of Las Ventanas' knowledge give it an idea that it needed to investigate? Not know, not actually know, but to have mere inquiry notice. And the allegations of the complaint and the briefing before this court make it absolutely clear that Las Ventanas knew everything it needed to know to investigate prior to at least by March 29, 2019.
And counsel, if I can interrupt, isn't that the point with it? You've got a nuisance next door. There's some level of inquiry that goes with that, especially when you're wondering, has it migrated as a party?
Absolutely, Your Honor.
And it was there for 20-some years.
Absolutely. Las Ventanas knew that the Perryville site was contaminated when it acquired the property. That is beyond dispute. Everybody knew that the Perryville site was contaminated because ADEQ announced to the world that the Las Ventanas site was contaminated. It's public knowledge, Your Honor. So certainly, Las Ventanas, as the adjacent owner next door, should at least understand the concept that pollution isn't stagnant. Pollution is dynamic. Pollution can move.
Counsel, are you arguing then that when they purchased the adjacent property, the 160 acres that Las Ventanas owns now, that fact put them on inquiry notice of contamination of their property, the property they were buying?
It certainly at least began the inquiry. It certainly began the question, Your Honor, because under Humphreys and similar cases, the question is, when does the sum total of knowledge accrue? And certainly that is a piece of information that Las Ventanas knew when it took a knowing gamble to buy 160 acres southeast of a contaminated and known contaminated site with two, not one, but two leaking underground storage tanks.
Well, but help me out on that. Are you arguing then that that's when the notice of claim period accrued?
Your Honor, it is a possible accrual point. Certainly no later than, we argue certainly no later than March 29, 2019. But it is a possible accrual point. And it's not
But
my...
under that theory, wouldn't any time anybody purchased land near a remediation site that ADEQ says, no, that land is not contaminated land you're purchasing, under your theory, the claim would accrue then?
No, Your Honor, because of the allegations of the First Amended complaint. Paragraph 34 of the First Amended complaint, which is Index of Record 4, Your Honor, the FAC alleges that ADEQ, quote, undertook a duty, close quote, in 1993. So Your Honor's hypothetical, perhaps if a purchaser comes to property with just knowing that there's adjacent contamination, certainly. Las Ventanas specifically alleges that not only did it know of the contamination, but that ADEQ has had a duty that has been running since 1993, before Las Ventanas even existed. And it purportedly...
What was that duty, though? It was to clean up the Perryville feed store property, not adjacent properties.
I would agree with that, Your Honor.
So
to the extent that there's a duty at all, I would agree that it was a duty to remediate that property, at least under the allegations it's pled in the First
Help me
Amendment.
better understand your argument that the claim then accrued as far ago as 1993.
And Your Honor, I want to be very clear. We need not, for purposes of today, we need not decide that it accrued in 1993. It is a possible accrual date, but we need not decide it, and I'll turn to the other facts in a moment. It is a possible accrual date because of the allegations in the First Amendment complaint. Las Ventanas has alleged that ADEQ began assuming a duty in 1993, before Las Ventanas existed. Las Ventanas knew on the face of the complaint, because Westside 1, the predecessor entity to Las Ventanas, had a purchase agreement fall through escrow with D.R. Horton, Your Honor. It knew when it sprung into existence in 2013 that the Perryville site was contaminated and that ADEQ had, in its words, assumed some form of duty to do something. They alleged that it was to protect them. We allege that it was, if it existed at all, it was to remediate. But nonetheless. But, Your Honor, that's just one stack, one penny upon the stack of knowledge that ADEQ had.
Can I interrupt with another stack that I think is important? At some point, ADEQ expressed some concern about migration because ADEQ said, Las Ventanas, can we put some monitoring systems?
Certainly, Your Honor.
And when did that occur?
2013, I believe.
So at least by 2013, ADEQ has expressed concern that it might be migrating, and Las Ventanas was well aware that it might be migrating, or at least there was concern that it could be.
Absolutely, Your Honor.
And then we get to the next step, which is the 2018 meeting, which is the one that we're the most focused on.
Well, it's even beyond that.
But there have been steps along that.
Certainly. And even before the step that Your Honor mentioned, which is the installation of the monitoring wells in 2013, Las Ventanas' predecessor entity, Westside 1 LLC, had a sale fall through escrow with D.R. Horton because D.R. Horton showed up, looked at the contamination, and this is all alleged in the First Amendment complaint, and said, we don't want to close escrow. We don't want to close the sale. And in the words of the reply brief, Your Honor, reply brief at page 3, that caused Las Ventanas to, quote, question the status of its own property. It certainly satisfies the inquiry notice standard as to when Las Ventanas is questioning the status of its own property. But we have even more than that, Your Honors, because we have the meeting minutes which are attached to the First Amendment complaint.
Counsel, do we know when Las Ventanas got those meeting minutes?
It is not in the record before the court, at least not to my knowledge, Your Honor, as to when Las Ventanas received them, certainly before it began this litigation. And certainly, sorry.
No, is that significant? I mean, what if they got them just a few days before the notice of claim?
It's not significant, Your Honor, because by attaching them to the First Amended Complaint and actually citing them as accurate meeting minutes, capital M meeting minutes, Las Ventanas is saying, Your Honor, take these meeting minutes as true.
And to help me out where they say they're accurate in their pleading.
Where they say that they're accurate?
Yeah.
They say that they're accurate at paragraph 28, Your Honor. It doesn't say the words, these are accurate.
I didn't remember
But it directly quotes the ultimate sentence of the meeting minutes of Exhibit 3 to the First Amended Complaint. And it's paragraph 30 of the proposed Second Amended Complaint, Your Honor.
And that, from your perspective, is a tacit, silent representation that everything in the minutes was accurate?
Well, it's tacit and silent recognition, but it's also explicit recognition, Your Honor. They attached it to the First Amended Complaint. Necessarily, the trial court can consider anything attached to the First Amended Complaint.
Right.
But in addition, there is no way to separate out, and there's certainly no case law that says that the trial court can or even should cherry pick pieces of the attachment to determine which is true and which is not true. When Mr. Gross's client attached it to the First Amended Complaint and said, Your Honor, read this last sentence. The citation of what they cite it for is the proposition that ADEQ and Las Ventanas agreed during the meeting that, golly, it would be in everybody's best interest to remediate the Perryville property as soon as possible.
Let me give you a hypothetical.
Certainly, Your Honor.
There's a set of meeting minutes that have two sentences in them. And a plaintiff believes the second sentence is accurate, but the first sentence is not. How should, if the plaintiff wants to rely on those meeting minutes, how should plaintiff attend to that document?
There's various and sundry ways that the plaintiff could attempt to deal with that document. The plaintiff could say, for instance, and allege, Your Honor, sentence 1 is accurate. Sentence 2 is not accurate, and we dispute it. But we affirmatively allege that sentence 1 is correct. That is markedly different, of course, than what happened here, where Las Ventanas doesn't say anything about the balance of the meeting minutes anywhere in its pleading.
And does that mean that any time a complaint attaches a document of any kind, it's vouching for its accuracy?
Whether or not it's vouching for its accuracy in the abstract, forever and for all time, for every type of document, Your Honor, academically, I suppose there's a hypothetical that one could conjure up where it wouldn't be appropriate. But this is an official government document. An official government document from a meeting that Mr. Tate, not just Mr. Tate and two lawyers from Gallagher and Kennedy were at, Your Honor. They signed in, attended the meeting, and the results of that meeting are promulgated in an official government document. Las Ventanas has never said, never alleged, and certainly never challenged the veracity of those meeting minutes before the litigation began and it realized the consequences of Exhibit 3. But even then, Your Honor, Las Ventanas continued to attach, even after the trial court's ruling about what Exhibit 3 meant and the inquiry notice that Las Ventanas certainly had. It's still attached to Exhibit 3. Exhibit 3 is still Exhibit 3 to the Second Amended Complaint. The only attempt to deal with the meeting minutes is one allegation and one minor sentence change, as you touched on, Judge Stone.
And just so the timeline's right, the motion for leave to amend to file the Second Amended Complaint was filed before the court issued its ruling.
That is correct, Your Honor. So the way that it played out was there was a motion, if my memory serves, and I believe this is borne out by the index of record, there was the necessary conferral under Rule 7, which is under the amended rules, counsel has to confer before filing a Rule 12b motion. There was the amended complaint. There was the First Amendment complaint was filed. The motion to dismiss was filed. While that was still pending, Las Ventanas filed two documents. The motion for leave to amend, actually it filed the Second Amendment complaint, and then we said, hey, why did you do that? And then it filed its motion, as well as the motion for summary judgment, which the court denied as moot and isn't before the court today. So that's the timeline, Your Honor.
So, counsel, given the 813 reference from Las Ventanas, why isn't there at least a possible inference that could be drawn? Because we're supposed to draw all inferences in Las Ventanas' favor at this point. Why can't we draw the inference that they are advocating?
Because the inference that they are advocating, Your Honor, first of all, is not a reasonable one, and second of all, is belied by the language
So
of
why
Exhibit
isn't it
3.
reasonable?
It's not reasonable, Your Honor, because as Judge Bailey began to discuss, not only does Los Ventanas know of the contamination of the property. We know that Los Ventanas has never disputed it. In fact, they affirmatively allege it. In the First Amendment complaint, Los Ventanas makes manifest that it knew and it was engaged in conversations with ADEQ. That's enough for inquiry notice. But even then, the rest of the meeting minutes confirm, and Los Ventanas has never denied this point, Your Honor. They've spent a significant amount of time disputing other points, but they've never disputed that, one, Los Ventanas was conducting its own testing of the soil of the Los Ventanas property. And two, Your Honor, that testing revealed actual benzene contamination of the soil under the Los Ventanas property. And third, Your Honor, Exhibit 3 to the First Amended Complaint and Exhibit 3 to the Second Amended Complaint specifically identifies Mr. Tate's request. Please start corrective action as soon as possible. Los Ventanas had a choice, Your Honor. It could either sit there and pretend like it did not know what was happening, or it could have done something. And we know it was doing something because they were actively conducting soil tests of their own property. And as Your Honor pointed out, permitting testing wells to be constructed on its property.
Counsel, go ahead.
Do you want to speak at all to the, whether the trial court should have allowed them to amend again?
Certainly, Your Honor. The trial court certainly did not abuse its discretion in denying leave to amend for various reasons, but the amendment would have been futile. The amendment would have been futile because, on its face, Los Ventanas knew, no later than March 29, 2019, for purposes of inquiry notice, that there was an issue, and it did not file a timely notice of
So are
claim.
you saying that Mr. Tate giving some sort of direct contradiction to the meeting minutes in a Second Amended complaint does nothing to further their argument here?
It does nothing, Your Honor, because of what Mr. Tate actually, what Los Ventanas actually alleges Mr. Tate knew. Paragraph 39, I believe it is, Your Honor, of the Second Amended complaint is what Mr. Gross represents as a, quote, direct contradiction. Set aside the declaration because it's not before the court. Paragraph 39 says, Mr. Tate did not know of the contamination until receiving this report. Your Honor, Mr. Tate doesn't need to know. Humphreys and the cases citing Humphreys and the cases that Humphreys versus State, Your Honor, rely upon. Inquiry notice is all that is necessary. It doesn't matter what Mr. Tate knew with respect to the contamination. All he has to know is enough to investigate, and paragraph 39 does not undermine at all, Your Honor, the inquiry notice.
Thank you.
Counsel, a couple of questions. You mentioned benzene. The March 29, 2019 meeting minutes mention nitrates, different polluting compounds. Are the presence of nitrates relevant?
The presence of nitrates, Your Honor, is relevant in that Los Ventanas has an idea that everything is not okay with its property, and everything is not okay with the groundwater. So the reasonable person that we're supposed to imagine for purposes of accrual would see, there's nitrates in my groundwater, and there's benzene in my soil. I should probably do something about that. I should probably begin asking questions about that.
Do the minutes mention benzene? I thought it was nitrates alone.
The minutes specifically mention benzene, Your Honor.
We have them, and I'll look at them.
Certainly. They specifically mentioned that there was trace amounts of benzene that were discovered, and they presented no vapor inhalation risk, but they were there and they were beyond acceptable levels.
Let me, one then final question that I have is the accrual of a notice of claim ever, in your view, a question of fact?
It could be a question of fact, Your Honor. There are cases frequently where it is a question of fact, and if you have, for instance, disputes as to who knew what and when, borrowing from the Watergate scandal, what did the president know and when did he know it? If there is some form of dispute about that, it is possible that it could create a question of fact for the trier of fact to ultimately determine. But that is frequently not the case, Your Honor, because Humphreys is a Jamal case, and there are myriad cases resolving accrual questions as a matter of law. And there's no reason why, on the face of the complaint, and the attachments, which make manifest that inquiry notice was present, there's no reason to decide that by a trier of fact. the court could absolutely decide that as a matter of law.
I just want to be clear on one thing to follow up, because I was going to ask, is them doing their own testing and that they found the presence of benzene in the record as well, and you don't need to find it, just I'm curious?
Yes, Your Honor, it is also Exhibit
Okay,
3.
I wanted to be sure.
It is also Exhibit 3 to the First Amendment complaint and Exhibit 3 to the Second Amendment complaint.
Thank you.
And Las Ventanas has never disputed that material fact, or that allegation, rather. I can't tell how many seconds I have left. Thank you, Your Honors. I'm happy to answer any additional questions. If not, then I will.
Thank you.
Thank you.
Mr. Gross, rebuttal, and I think
Thank
you're
you.
about 2.5 minutes.
I'd like to make 3 quick points.
Very well.
Or maybe 2. The first is that in terms of investigating, Las Ventanas was investigating. They allowed ADEQ to put monitoring wells on the property. They were asking ADEQ, is the property contaminated? The consistent answer was no. No, the property's not contaminated. Yeah, they knew the adjacent property was, but there's just a difference between being next to adjacent property and owning adjacent contaminated property in terms of what that effect is on
But counsel, once you
on the
find
property.
benzene on your property,
Let's talk about the
how does
benzene.
that not at least flip it to at least the standard of should have?
First of all, we don't, in terms of damage, we don't know anything about the impact. It says trace benzene. What is trace? Don't know. It said it may impact the site. Does it? We don't know. Is there damage? We don't know.
But that
But-
suggests that you should be looking at it.
And
That
we were.
suggests that the
And
migration may have occurred.
And they were, and did not decide that it presented a damage. And that is, in the totality of the circumstances, why we should be permitted to amend the complaint to make those allegations. And again, you know, you discussed the timeline of the amending of the complaint and the motion for summary judgment, motion to dismiss. The trial court didn't focus on the one sentence in the minutes until the oral argument, which is after we filed the motion to amend. We did include that we didn't know, but in terms of facts being susceptible to proof, that's shown in Mr. Tate's declaration. This isn't a case which would be futile because amendment can take care of those problems and would take care of those problems, and we should be entitled to amend because, again, Las Ventanas was doing their own investigation and was consistently told by ADEQ, your property is clean and we're remediating the Perryville site. Thank you.
Thank you.
Counsel, we appreciate your briefing, we appreciate your arguments, and we appreciate your indulgence. The courtroom can be an anxious place for many, and that's the typical courtroom, let alone in front of many, many observers. But thank you for your graciousness in participating. We will take the matter under advisement. We will issue a written ruling in due course. The court stands adjourned.